Good evening. Welcome to the Lifeline on Equa TV Africa. This is a legal show that discusses legal matters. I am Victoria MC Olanium. Today we'll be discussing various issues as you know the program unfolds. This is a call-in program, and at 6:30 the phone lines will be open, so you can call in to make your comments and give your contributions. You could also ask your questions. In the past week, we experienced, various decisions of the federal high courts on matters of defection, and this, has been in the discourse for a while now. So we will also lend our voice to that discourse. Also, we'll be looking at the issue of the decision of the court, Federal High Court, on the matter under Section 84, Sub 12 of the Electoral Amendment Act. So our topic today will be political defections and legal matters arising. With me in the studio to discuss this interesting topic is Barrister Stephen Ahili. You're welcome.
Thank you. Good evening, viewers.
And we also have Barrister Godfrey Matthew. Thank you for joining us.
Good evening, viewers. My pleasure.
All right. So we will go straight ahead to, asking Barrister Ahili for a member of the House of Rep or a member of the House of Senate to defect to another political party while in office. Is that constitutional?
Well, a member of the National or State Assembly, that is to say, the law is very clear on the issue of the defection.
Okay.
Ordinarily, it is not expected that political parties, members of legislative houses will defect. However, there is a provision that allows defection in situations where there is crisis in a particular political party.
Okay.
The courts are pronounced on that. But where there is no such crisis, there is no, the law does not allow an elected legislator to move or defect from one political party to the other.
Okay. Barrister Matthew, I don't know, do you have something to add to that?
Really, defection has to do with a situation where a political party member moves from a party that sponsors him to another party.
Okay.
And in defection, you have two types of defection, where you move from the cause and effect from one destination to another, and then where you move from one place also to create a separate political entity. For example, you can decide to defect from PDP and then create another political party that does not exist. While in the first type, you will have the one that you will leave a political party that is in existing and join another political party that is existing. So these are some of the things that I would like to add.
The two scenarios where a person can defect. Yes. Okay, so still with you, when you say, Barrister Ahili said, you can defect when there is a crisis.
Yes.
Okay, what level of crisis? Do I find the fact that I and a member of a political party, of my political party, are not in agreement, and then I call that a crisis, and that makes me, I'm dissatisfied with my relationship with members of the party, and then I move? Or does there have to be a level of crisis, in that political party for that condition to be fulfilled for me to move?
Thank you very much for this very interesting question, because this is one of the areas that we're mixing the truth perception and the constitutional import of the political defection. But before I answer that, let me give you a brief history lesson.
Okay.
When Nigeria was on the countdown of becoming an independent nation, the colonial masters asked all the Nigerian segment, north, west, south, to form political parties.
Okay.
In the 1951 Constitution under Macpherson, the Western Regional House of Assembly, the highest members that form parts of that legislative house were the National Congress of Nigeria and Cameroon.
Okay.
Now, when that made Nnamdi Azikiwe with the highest majority to become what? The premier. But because some people felt that no, how can in Western House of Assembly somebody from East will become the president? So they lobbied, and there was a mass defection from NCNC to Action Group. That's the first instance of political defection. We went through that, we survived it. Nnamdi Azikiwe resigned as a member, then went to the Eastern Nigeria. Before he's coming to the Eastern Regional House Assembly, it was Eyo Ita who was the premier of Eastern Nigeria. Eyo Ita is from Calabar, but because he's also from minority, the Igbos now say, let's bring our own, and they made him to become the what? The premier. That's how the genesis from. In the countdown to 1962, after independence, we saw the same thing happening. Also, you see it that there was an alliance, a defection between Akintola in Action Group to form alliance with Sardona and NCBC. So that led to a lot of political crisis. Unfortunately, the 1963 Constitution did not address that. When we come to the 1979 Constitution, that clause was now formed under Section 64, sub 1G for defection from House of Assembly, from Senate and House of Representatives. Then 10G, 109 paragraph G, settled the one with respect to the House of Assembly belonging to the state. What does that section say? A member of House of Representatives member of House of Representatives or Senate may vacate his seat if one, paragraph G, he defects from a political party that sponsored him to that election. Then the proviso say, provided there's no merger, provided there is issue of what? Division. Now, that section was tested in the case of Goni versus Fedeco. What happened in Goni versus Fedeco? In Goni versus Fedeco, the former governor of Borno State, who is Mohammed Goni, was was in Great Nigerian People Party. Okay. Now, when he was a governor, there was a division. Some members of the Great Nigerian Movie Party joined MPN, while others joined UPN. Okay. Then he decided to defect and then join NPN. And then he won an election. It was taken to court. And the court gave a clear definition that as far as what constitutes division, that division must be such a one that will have a national reflection. And it is not a reflection that will be between a party chairman in Plateau State and his legal advisor. It's not the one that will be between a party chairman and what electoral officer. No, it says it will have a general coloration. Now, the same thing also happened when it comes to Sunday, Efedayo Abegunde versus Ondo State House of Assembly. It was reported in 2011. In that case, the same thing also happened. When Sunday Efedayo was with Labour Party, there was a crisis in Ondo State. Now, he left Labour Party to ACN. And the Speaker of the House of Assembly wanted declaring his seat vacant. He went to court challenging that he should be stopped. But the court said no, that the defection is a constitutional duty of the Speaker of the Assembly. For defection to warrant for decamping from one party to another, it must be a one that will have a national reflection. The fact that is concerned is that in Ondo State, the Labour crisis is between members of the Labour Party in Ondo State. It's not that they have separate chairman. A typical context you will situate that is that when you say you have a division that will substantiate or justify your moving cross-carpeting, it means that the party must be divided. You must have PDP chairman 1, PDP chairman 2, PDP 2, PDP 1, like we had in the day of Ali Modu Sharif and late McCarthy. So you will have a legal advisor for this team. When such things happen, and like in the case of Goni, there's NPN, GNPP, there's UPN, GNPP. These are the conditions that the court satisfy, that it will just be justified. So these are the conditions. But a clear and unbiased appraisal of that constitutional provision also need to be revisited, because it is, in a true sense, it is not all parties that have wider coverage. There are some parties that their main role is usually within a state, within a region. So once you find out that, you say it must have a national coverage as far as the division of fractionalization is concerned. And also, there are some parties that are the division that is mostly state-centered. When you say a division in the House of Assembly, which is a state House of Assembly, is a state arm of the government, must have a national reflection. The same with the Federal House of Government. It's against the ethic of federalism and the third tier of government. Let the House of Representatives have a national reflection when it comes to division and fractionalization. Let the House of Assembly also have a state. If we are saying that I'm a member of House of Assembly, I cannot, what is my business with the national? If there's a division in the State House of Assembly, if we follow the federalist structure, it is more appealing. Yes.
Thank you very much. Barrister Ahili, you know, going by the decision of the court in Ebonyi and in Ebonyi State, where the governor and his deputy have also been sacked because they have defected. Does that have, is that, will we say that's constitutional, or is there, is the law binding on them also not to defect, being the part of the executive and now not the legislature?
Well, we had discussed this here before, and what we said is that the law does not make express provision in relation to the seat of the governor. Okay. But the law makes provision on circumstances and situations where the seat of the governor will be declared vacant, and defection is not part of it. Okay. And so, strictly interpreting the law, you will not find it there. However, the other aspect with the other perspective is that candidates are normally sponsored by political parties. And even where a party is given a certificate of return, the certificate of return reads something like, this is to certify that so person of so party. Political party. So it is not the person's mandate. It is mandate with the party. And in Nigeria, we do not have independent candidature. There's no provision for independent candidature. You must be sponsored by a political party. Okay. So you cannot come from the blues or from outside just on your own and come and contest the election. So the votes that are being cast for you are being cast for your party. It happened when Rotimi Amechi was substituted by another candidate. I can't remember the name now.
Celestine Omehia.
Oh, Omehia, yes. So the court held that the votes that were cast for Celestine Omehia were not for Omehia but for PDP. And so Omehia was ordered to vacate the office while Amechi was declared, who was the initial candidate of the party, was given certificate of return and sworn in as a governor, and he did his 4 years and got re-elected and did another 4 years. So, in fact, in his own case, it was not even made to be in such a way that his time began to run from the date he took oath of office. It started from the date Omehia took oath of office. Wow. So, when you look at it from that perspective, this mandate is not your own. So you cannot take the mandate and give it to another political party. The mandate belongs to the party. So I think from this perspective, even though the law is not explicit on making a provision for what to be done in case of defection, perhaps it is not even contemplated that the governor will defect from one party to the other, since the mandate is not just his, but also that of the party.
Okay. Thank you very much. Barrister Matthew, looking at the decision of the courts, the Federal High Court in Abuja, many have have different opinions. I would like to know your own opinion on this. Whether the Federal High Court Abuja had the jurisdiction to hear these matters and also, give judgment in these matters, especially that from the Ebonyi and Cross River State, where the lawmakers have been sacked from office. The issue is, the Federal High Court has divisions in these states. Why were those cases not instituted at the Federal High Court within their division? And now it's taken to Abuja, the Federal Capital Territory. Does the court have jurisdiction?
The court has jurisdiction. It has jurisdiction entertaining that matter, and that jurisdiction is equally recognized by the law.
Okay.
First, the division of the Federal High Court is for administrative purpose.
Okay.
For administrative convenience, so that you cannot be going to Abuja to say because Abuja is a federal capital, you are going to file a case on Federal High Court there. That is why every state virtually has a Federal High Court. Now, apart from that, the concept that the proponents of the view that the court lacks jurisdiction are trying to promote is that the territorial jurisdiction,
yes,
and mostly the concept of territorial jurisdiction applies more, in my opinion, when it has to do with the criminal matters, where the accused resides, so that you can get the accused in the Federal High Court of that state, try him with the jurisdiction. But even in Federal High Court, where the accused has a tendency of posing national threats or security risks, he can be taken to another jurisdiction, from, let's say, Plateau to Taraba,
okay,
or from Kaduna to Adamawa. Is Federal High Court. So that one is not. The other thing I want to talk about regarding the substance of the judgment given with respect to the river is the issue of our jurisprudence, the legal philosophy behind the defection of a governor and other top executive like the president and the vice president. When it comes to the president, the court, the vice president, the president, the governor, the deputy governor,
yes,
the court has a settled position in law. The case of Goni, Mohammed Goni versus Fedeco that I cited, in that judgment, the court held that the provision of section 64.1G that talks about the defection of a senator and 109G that talk about the defection of a member of House of Assembly does not apply to the executive. Now, the error of that judgment was that, in my opinion, there was a provision under the 1979 Constitution that talks about 116G. It says if any governor is found wanting in any of the offense that disability that would be associated with the senator, member of House of Representatives, he can equally be what? He equally has a incapacity. Now, that 1661 was not addressed in the case of Goni in 1983. So when they come to the amendment of the 1999 Constitution, at that time, they smuggled that section out. So they left the 64.1, which is now 68.1G, and the 109.1, which is they left it like this. And so when the incident in Atiku versus Abubakar Atiku versus Attorney General Federation came in 2007, when Atiku said, I'm leaving PDP, I'm going to CN, the court still reinstated virtually everything in that judgment. I adopt the position in Goni and equally won. They lamented in the manner that Ahile was equally raising, the morality of political defection. They said, no, the vote initially belongs to party. The people that voted, they want you because you are representing their interests. So why should you go to another party? So if you look at the historical antecedent we laid earlier on, and you look at why the Constitution makes a justification, you will now find out that, frankly speaking, the Constitution appears to be liberal to the executive than to the judiciary, to the legislature. So it is strict on the legislature, but it is casual on the executive. A governor can decide today and say that, okay, by the provision, and Constitution is a statute that needs strict interpretation. Generally, other statutes, the provision needs strict interpretation. Now, coming to an omission or express omission of something that is not stated in the Constitution, you have a law to operate it as it is. So we can keep lamenting on the situation. The best way to address this, in my opinion, is the constitutional amendment to say defection of a political governor equally attracts the same sanction as that of the political legislature.
Thank you very much. Okay. Barrister Ahili, what will you say? Will you say this discourse, these issues that have arisen out of the decisions of the court in Ebonyi, the Ebonyi case, and the Cross River matter, will you say it's in the interest of our political system and Nigerians at large, considering the 2023 elections are by the corner?
Yes, we have a political culture that has been bastardized. And these decisions, in my own opinion, are good. That in that they will make people to think twice and not just, for whatever reason, move from one political party to the other. That is destabilizing our political system, is destabilizing the entire, and then again, it also questions it questions the sincerity of our political office holders. And in other words, it goes to show how people are simply serving their selfish interests and not public interest. Because if it were public interest, every party has its own manifesto. The manifestos of the PDP are not the same as the APC. So why will somebody who saw the two political parties and chose one find it so easy to junkate from one political party to the other? It goes to show that it's just their interest, their selfish interests they are serving. So whenever their selfish interests are no longer served in a particular political party, or they feel that their selfish interests are threatened, they will quickly defect from that party and go to the other. And that is not good for our political system. We can see that we are rather retrogressing and going down and down and down. They keep talking about the good old days, the good old days. Even for some of us, when we look at, I was thinking the other day that I went to school for how many years, up to postgraduate level. But the school fees I pay for my small son for just one session in primary school is more than the school fees I have spent in my entire life. So it is very unfortunate. We are just going down and down the drain. So if these things are happening, people will think twice and then try to work for the good of the state. I think even where they have divisions of national character, it is not disagreements on public interest, but on simply selfish interests. So this will make people to sit up and help our political system.
Barrister Matthew, do you have anything to add before we go for the break?
Yes, you see, one of the political causes of defection, like he said, we have selfish interests, you know, the desire to achieve something that the party does not approve. So you want to do it in another alternative. Then aside from that also, you have lack of clear-cut ideology of most of our political parties.
Very true.
Because when you have ideological setup in a party, these are the goals that we seek to achieve, you can do. Also, the lack of compliance with the ideology or the mission and vision of a party will make somebody to decamp from the party. A typical example is the case of Benue State Governor. I like citing it because when he joined APC, the expectation is that they are going to fight insecurity and doing most of those things. But when you find out that the APC, according to him, are not living up to that ideological contract they signed, protecting the life of the Nigerian and their citizens, he decamped to PDP. That could be justifiable. Then you can also see persecution also. When a particular candidate is being persecuted and he found out that things are not going well, not only for his interest, but for ideological interest, and when opportunity creates itself in terms of division, he may elect to decamp to another party. And in Nigeria, the recent cause of defection now is fear of prosecution. Adam Oshomole has substantiated that. He says, once you have come to APC, all your sins are what? Are forgiven. So many people see that as an opportunity to jump from one party to another, especially from opposition party to the ruling party.
Thank you very much. We'll go on a short break, and while we're back, we'll have some further discussion. Thank you very much. You're welcome back. If you're just joining us, this is the Lifeline on Equa TV Africa. We have been discussing the topic, political defection and legal matters arising. We just rounded up our discussion on the issue of the defection in Ebonyi State and that of Cross River. We will be looking at the decision of the Federal High Court in respect to Section 84 sub 12 of the Electoral Amended Act 2022. But the lifelines will be open, so you can call in to make your comments and your contributions while the discussion is on. Barrister Matthew, I'll begin with you. In your own opinion, the decision of the Federal High Court, Abuja, striking down Section 84 sub 12 of the Electoral Amendment Act, I don't know, will you say that is constitutional?
I will say it is not constitutional, but as far as it's a judgment that emanates from court, I can say it has a legal backing.
Okay.
Now, why is it not constitutional? It is not constitutional because from the power provided by the Constitution to the Honorable Attorney General of the Federation, striking or deleting a section of any law that is validly enacted by National Assembly is not within his statutory or constitutional contemplation. It contradicts Section 4 of the Constitution of Nigeria,
okay,
that said the National Assembly has a power to make laws for the good order of Nigeria. And doing that, it doesn't. But relying on the order of the court, an act may be lawful for a beginning, but maybe at the time goes on, it may not be lawful. Because that judgment, deleting it, clearly is in contravention of the Constitution. But as far as the law is concerned, we say, remember we are talking here, we say no matter how perverse judgment of court is, it is still valid. So as far as the law is concerned, he is now by the director of the court to delete the section. Nevertheless, once there is an appeal to stay of execution, he must not delete that section. He must wait until further appeal is heard and verdict is found to determine the validity of the judgment.
Okay. So what we are saying is, as it stands, that the judgment of the court is still valid.
It's still valid and subsisting.
It's still valid and subsisting. Yes. So, Barrister Ahile, will you say has the court of appeal right now stayed execution, or is
question.
okay? Sorry, before you make that comment, we have Kelechi from Ebonyi. Kelechi, you're welcome. Good evening to the show. What you want to make your comments, you can go ahead. Oh, sorry, we lost that caller. Kelechi, you can do well to call back. So as I was saying, has the Court of Appeal stayed the decision of the Federal High Court presently, or is still subsisting?
No, the decision has not been stayed. It
Okay.
is still subsisting.
Okay, we have Kelechi back on the line. Kelechi, you're welcome to the show.
Okay. We don't know our stand now. Does it mean that we don't have governor now? Yeah, thank you.
Okay. Our question is, does it mean that they don't have a governor presently as it stands? Barrister Matthew, do you want to answer that?
They have a governor.
Okay.
They have a governor because by the order of that court, the PDP candidate ought to be sworn in by INEC as governor. But Umwai is fighting battles to stay the execution of that judgment. Remember, I told you some other day that these are the things that we shall be experiencing, and we are seeing it now. Today, I think yesterday, the court struck out the motion for stay in execution by Umwai. So, de facto governor now, Umwai still remains the facto governor of Ebonyi State.
Okay.
In the eyes of the law. Or if the PDP candidate is sworn in, they have. So you people in Ebonyi still have a governor by name Engineer Dave Umwahi, though in a de facto status.
Okay. So does that mean he can still keep running, and he can still act, attend programs as the governor of Ebonyi State?
Yes.
Okay.
Yes, he can do that.
Okay.
Because he can do that.
All right, we also have Charles from Ebonyi. The people from Ebonyi are really interested in this matter, and I can understand with you. Charles, you're welcome to the show. Hello, Charles.
Yeah, good evening.
Yes.
The guest in the radio.
Thank you.
Yeah, this is Charles from Ebonyi.
You're welcome. Please, you can make your comment.
I am really bothered about this issue because, as a matter of fact, now it seems as if the seat of the governor is vacant, and there is politics going around the issue of removal of the governor. Because stay of execution, I don't know why it is taking too long for Court of Appeal to grant that stay of execution, or even the Federal High Court that sacked the governor. So what is keeping the stay of execution from being granted? That's my question.
Okay, thank you very much. His question is, what is keeping the Court of Appeal or the Federal High Court from granting the stay of execution? Barrister Ahile, please, can you speak to that?
Well, the Federal High Court cannot grant the stay of execution now because it no longer has jurisdiction. It has become functus officius. The application was filed in the Federal High Court. However, there is what is called an appeal has been entered. That is where the record of appeal has been compiled by the trial court and transmitted to the Court of Appeal. In this case, the record of appeal has been transmitted at the Federal High Court Abuja and compiled and transmitted to the Court of Appeal. From the moment it was transmitted, the Federal High Court ceases to have jurisdiction, so they can no longer do anything on the application. That is why he withdrew the application and it was struck out.
Okay.
Now he has already filed an application at the Court of Appeal, but this will have to be served on the parties, and the parties will respond before it will be heard. And there is there are timelines for filing. When it is served, the respondent has some days within which to respond. And then after they respond, the applicant will also have to reply if he has any replies. So it will take some days. In as much as we are itching to hear the result, it has to take its natural course. You cannot go outside of it. Once that is done, it will be wrong and it will be subject to being set aside by the Supreme Court.
Thank you very much. Barrister Matthew, like we were saying, the order of the Federal High Court on issue of striking down that particular section, subsection of 84, Section 84 of the Electoral Act, and the AGF, what is the propriety, of the AGF handling, going further to take action? Because we hear that he says he will comply with the decision of the Federal High Court.
In fact, his media assistant came out to say that they will comply with the order of the court. But you see, as for the way things are now, there's no any effort that is taken, because he knows that the parties affected who were technically and shrewdly excluded are even considering challenging the judgment.
Okay.
And as I'm talking to you now, it is not only the National Assembly that can challenge that judgment. Civil organization can equally challenge that judgment because it affects public interests, okay, of national concern. That is the political situation. And going by the way, the National Assembly, civil liberty organizations, as well as other meaningful or related organizations, could challenge it, pointing out the impropriety. Now you ask yourself this: why is it that in this government you are finding challenge with compliance and paradox of compliance? Ebonyi State judgment was given by Federal High Court based on a reason and well argument where parties are represented. We are struggling for compliance with that judgment now. Now the one that was shrewdly, parties were arranged, let me put that way, as others are calling it, we were won by the notice intemperance. Parties, it appears as if it's a scripted trial without involving the parties concerned. And why is it that the government is diligent in executing that judgment and appearing prospective to comply with that judgment more than the one of Ebonyi? So you can see the morality and equally the equity in compliance does not really speak about the justice of the case that Nigerians are yearning for. Why is it on the one side of the domain you are complying, on the other
hand you're refusing to comply? Yeah. Okay. Like he was stating, Barrister Ahili, let's hear your view. The National Assembly, what is the way forward for them now, based on the decision of the court in this matter?
Well, the decision, the National Assembly has an option of appealing that judgment as interested parties.
Okay.
By leave of court, they will apply to the Court of Appeal to appeal the judgment, or in fact to join in the appeal that has already been. Sorry, yes, they have the option of filing an application for leave to appeal that judgment as an interested party. And my colleague mentioned the issue of others saying parties were arranged. It is really curious that this kind of issue came up, because I was looking at first, I was wondering, say, who are the parties in this
particular suit
judgment, in this suit? And I eventually got to know that it is one Chief Nduka Edede that sued the AGF. The curiosity is heightened that the president, probably ostensibly on the advice of the Attorney General of the Federation, wrote a letter to the National Assembly requesting that this particular provision be deleted. That the electoral be amended by deleting this particular provision. not even amongst other provisions, this particular provision. And so it becomes very curious how the Chief Nduka Edede, what is his own interest that is above every other person, that he will sue part of the executive that had requested that this law, this particular provision of the law, this particular subsection of the law should be deleted. Then you now sue the same person who wanted it deleted. So that is why it looks like arranged parties. So it is very curious, and it goes to show the kind of society we are living in. And I wonder, when these things are happening, I wonder what the people think will be viewed in the eyes of the international community, how they will view us and rate us as a nation. And when they say we are Banana Republic, people get angry. When the President of the United States was quoted to have said we are shithole countries, people were angry. But on a daily basis, we show that there is something wrong with us.
Thank you very much. Barrister Matthew, we'll say, looking at all these decisions from last week to this week, do you say that judiciary is there more to ask of the judiciary, or we're already on top of our game?
I think I must commend the judiciary for taking bold steps to sanitize the polity. You know, once you look at the effects of political defection to national unity and political stability, you will find out that it has a negative impact.
That's true.
Most from the historical instances we cited, you find that Western regional crisis of 1960, most of this in on those states in 19, all as a result of political defection. You know, so now they know how the system is tense. Socially, the system is tense. Economically, the system is unfriendly. Culturally, we lack moral values. So all we need now is a small political discontentment to ignite national security. But I think judiciary in their wisdom has taken a passionate step to say, hey, we have to sanitize the system. People whose defection is randomly done, we are going to follow the law strictly. That's when you see 17 people in Akwa Ibonyi were sacked. Why were they 17 people? Why will the 17 people left their original party to join the governor? The question now is that the governors normally carry them, because political defection, one of the things we don't know about the issue of political defection, like I said in the 1979 Constitution, political defection could equally form a ground, if you have a good House of Assembly, to impeach the governor. So what the governors normally do is that to carry them 75 to 85% of them with them. Look at Cross River. I don't know the number of people in Cross River. 20. No, I'm talking of the total number.
Okay.
So if you take 20 out of them, so you find out that maybe you have about 4 or 5 or 2 persons, 1 person that is on opposition, and when he comes, it's always a loner. So can he institute impeachment? No. So they are now saying that let's sanitize the system. We are sanctioning these 20 guys. We are sanctioning so that everybody will sit on his toes. We can only allow defection when it is justifiable, as contemplated by the Constitution. So that's why and how you see this is done. So it is a step that is taken to sanitize the system. And I think also the judiciary should equally gone further to help. Look at the judgment in Ebonyi. Even though I don't totally agree with the sacking of the governor as on ground of defection, because the Constitution does not say so. But one of the consequential orders they made, how I wish is what they would have made also with respect to legislators, so that it will save cost. If you see all these legislators and say that all the people that represented them or seconded them should be what? Should be automatically released, because declaring their seat vacant, constituting election is another heavy cost on taxpayers' money. And INEC is also overstretched. So that's why I said earlier on that by the time, if we don't sanitize the system now, we will reach a stage in Nigeria whereby we'll have a judgment, an election in 2024, an election in 2023 and 25, 2026, and 2027 up to 2028. Because we are now having political calendars that differ from the main general election as a result of what? Judicial intervention, sacking governors that have not been are not complied with electoral process and the constitution. So this is what judiciary has done, and it's commendable. And we are seeing further that how this development, like the morality, people are talking about governors. Why is it applicable to legislators? Why is it not justifiably applicable to the governors? That should inspire us towards constitutional amendment to see that that is captured in the constitution. Or on the alternative where, like in the 1979 constitution, the import of 1661 there, is that where he defends is unimpeachable. Where you can see now they are carrying everybody, or virtually all the members of the assembly with them. And we thank the judiciary for sanitizing the system. They will now know how to approach these issues next time politically.
Thank you very much, Barrister Healy. Can we just hear your last words before we round up?
Okay, yes. Let me say this, which I didn't say before, that part of the judgment, the reasons for striking down the Section 84, subsection 12 of the Electoral Act by Justice Anyadike was that it is inconsistent with Section 6, subsection 6, Section 66, subsection 1, paragraph F, Section 107, subsection 1, paragraph F, and Section 137, subsection 1, paragraph G. It is insightful to note that these sections are not relevant to have formed the basis for striking down a provision of the Electoral Act. These provisions are made in relation to 30 days requirement for civil servants and public servants to resign from office before 30 days before the date of election. It does not apply to political appointees as provided in the Electoral Act. And Section 137, subsection 1, paragraph G is on disqualification for contesting election. So if you have not, if any of the, either a public officer or a civil servant has not resigned or retired from his office 30 days from, 30 days to the date of election, he's disqualified from contesting. So it doesn't have anything to do with the provision of Section 84, subsection 12. So that section is not inconsistent with these provisions of the Constitution as she relied on and went ahead to strike down that particular provision of the Electoral Act. So finally, I will say that...
Please, in 30 seconds, we have to go.
So far, so good. The judiciary is doing well. Even where we do not agree with them, we do not have to castigate them. We do as we do in court. When they pass a judgment, whether we like it or not, we say, as the court pleases, we thank the court so much for the well-considered judgment. But when we go on appeal, we now say the court held in law when it hears so and so.
All right. Thank you very much. This is the much we can take on the show. We will await the decisions of the Court of Appeal on these matters, and I'm sure we will be back here to discuss them. Thank you very much. See you next week, same time.
Thank you.